Are you wondering if sole custody is an option for you and your child? Well, you're not alone. Knowing when sole custody can be granted is critical. Hi, my name's Miguel Jeffrey. I'm a litigation attorney here at Melone Hatley. This video, we're going to explore circumstances where sole custody realistically can be pursued and granted, giving you clarity and confidence as you move forward during this difficult time. The first situation where sole custody could be granted is if a parent is doing something to endanger the well-being or safety of the child. The reality is that courts abide by what's known as the best interests of the child standard. And with that standard in mind, anything that poses a risk to the best interests of the child will be taken very seriously. Examples of this could include something like abuse, neglect, substance abuse by one of the parents, even domestic violence in the presence of the child. Best way to go about addressing this issue is document extensively, and if need be, get professionals involved. Call the police, call Child Protective Services. But there is one caution to that. Be very sure that when you call CPS or the police, it's for a very legitimate reason. Otherwise, it could be looked as you acting vindictively and just trying to one-up the other parent, which could backfire in your pursuit of custody. As usual, it is a good idea to consult an experienced family law attorney before you take this kind of step. The second situation is when a parent is unfit. Common examples of this would be severe mental health issues. Perhaps the parent is serving a long term of incarceration because they were convicted of a felony, or they're just very unstable. They don't have a stable home, they don't have transportation, things of that nature. Again, extensive documentation is going to be your best friend. And in the cases of incarceration or severe mental health issues, you could also use that documentation to help your case. However, for legal purposes, you may not be able to readily obtain that documentation. So as usual, it would be good to consult with an attorney who is able to subpoena that for you. The third situation where sole custody can be granted is if a parent is absent or has abandoned the child. Now, this usually involves something along the lines of the parent's been gone for months, or perhaps they've not reached out to their child in months. It wouldn't deal with something like a military deployment. That's a whole different situation. But if you're the parent where you're taking care of your child, the other parent has been gone for a long time, you can even make your case better by reaching out to that parent and trying to get them involved with your child. Because when that goes before the judge is going to think that you are exhibiting good co-parenting, you're making the child readily available for the other parent. That'll only really strengthen your case. And the last situation we'll discuss where sole custody could be awarded is one where the other parent just absolutely is unable to co-parent with you. Now, this has to be more than just they make you angry or they don't like you or they make things a little tough. It has to be to the point where it's detrimental to the child's best interest. For example, let's say that the other parent takes the child to the doctor, doesn't make you aware. The child's diagnosed with a certain sickness, they're prescribed antibiotics, they need to be given over 10 days. Maybe 5 days into the antibiotics, you exchange the child, so now the child's with you, and you have no idea about anything that's gone on. That's a situation where potentially this was detrimental to the child, especially if the symptoms worsened because the treatment wasn't completed, and that could help you in the bid for sole custody. But again, you would want to consult with an experienced family law attorney before you take any steps. In some, sole custody is a high bar, so you want to make sure you have the evidence that you need. With that said, the legal process can be summed up in a few steps. The first step you'd want to take, although it doesn't necessarily have to be the first one, but you'd want to gather and obtain all evidence that's relevant to your claims. That would be really helpful before you meet with your attorney and speak with your attorney so the attorney can look at what you have and give you a recommendation. Now, you can do it the other way too. You can meet with an attorney first, they could give you some guidance on what you should gather, and then you could proceed that way. But those two steps are going to be the first steps: gathering and obtaining the evidence, organizing it in digestible form, and meeting with an attorney. Now, if your attorney decides that you have a pretty valid claim, your attorney is going to file a petition for custody and support. Now, that in itself can still take some time to come to fruition. The fourth part of the process is the actual court hearing itself. Most of the time, it's going to be more than one hearing. A couple months after you filed the petition, unless it's exigent circumstances, urgent type of situation, you're going to go in front of the judge for the first time in a couple months. But most of the time, that judge isn't going to make a final ruling there. That judge is going to want to appoint what's known as a guardian ad litem, or GAL for short. It's basically a fancy way of saying the minor's attorney. And that attorney is going to make recommendations to the judge for custody. But that will not happen at the initial hearing. The GAL will need time to talk to both parents, talk to the child, talk to providers, etc., etc. So usually the process is petition is filed, you go to court a couple months later, and then maybe a few months after that, you have your final trial. So to recap, you're going to gather and obtain evidence, you're going to speak to your attorney, petitions are going to be filed for custody visitation, there's going to be hearings, and then of course at the end, the judge will rule one way or another. Now, some practical considerations to keep in mind about this process. Foremost, it's been alluded to already in this video, but the best interest of the child standard. It's a child-centered affair. You always want to approach your situation with those lens. If you approach it through the lens of how much you hate the other parent, how much they don't like you, the things that annoy you about them, it's not going to get you very far. Instead, you need to approach it in terms of what's good for the child, what's bad for the child. That's what's going to ultimately be what the judge cares about. And beyond that, you need to be ready for extensive investigations and even evaluations of yourself. It's going to be a pretty thorough process. The GAL is going to want to speak extensively to both parents. And depending on your case, you might even have to undergo what's called a parental capacity evaluation, especially if you're asserting that the other parent is unfit or something along those lines. It's almost always a all or nothing type of deal. The courts won't just have one parent do it. They'll have both parents do it because the psychologist needs both pieces of the puzzle to make recommendations. If you do a PCE, parental capacity evaluation, you're basically going to a psych eval, a parenting assessment. You're speaking to a psychologist for an hour answering questions. So you just have to be mentally prepared that you're going to go through a pretty rigorous process. But if you keep that in mind and the best interest of the child at the center of your focus, you should do well during your custody battle. So what does this all mean for you? It means that navigating a sole custody legal proceeding requires expert legal guidance, but it also requires compassionate support. And at Melone Hatley, we'll advocate fiercely for the best interest of your child. So please give us a call today, discuss your situation with us, and we can work together to protect that which matters most.